Okay, well, I'm very honored that you all asked me to join you today. I know that it has been a really tough year. We came into this year thinking we were going to get to do so much activism and finally be heard on the high cost of drugs. And then COVID happened, and that's caused all of us, I think, to have to expand and pivot and rest. And we're now having a long overdue racial reckoning, which is adding, I think, much needed dimensionality to so much of our work. And so I was asked today to speak about the drug patent problem and how more activists can join this fight. So I'm going to focus my comments there. And I'm going to do it in three parts. First, I'm going to share my story of how I came to this work and why I've chosen to focus on patents. Then I'm going to go into some diabetes medication case studies to illustrate how patents play a role in the high cost of drugs. And then I'm going to end by offering some advocacy strategies that you all might want to, or frameworks actually for thinking about advocacy strategies that you all may want to consider as you embark on your next chapter. So with that, about 20 years ago, came to this work. When I graduated law school shortly thereafter, I moved to India and I worked for an organization called the Lawyers Collective, which is a human rights NGO working with people living below the poverty line who couldn't afford their medication. And one of my very first clients, I was asked to set up an office to service South India. And I was running a team of 10 to 15 advocates, community organizers, and legal aid lawyers. And one of our very first clients when we set up the South India office was a family of 5, a mother and father who were at the end stages of having AIDS and knew that they weren't going to make it because even though the medicines existed, they weren't reaching most people in the global South at the time. And so they had come to our office to ask us to draw up adoption and guardianship papers for their 3 children. And it was really heart-wrenching for me as an American working there at the time to realize I was an HIV counselor here before I went, and I realized that people here were able to get the medication and people there weren't. And this family was literally going to be separated just because of the high cost of drugs. And so that was what started to really build my passion for this work, that really no family should be separated because of the way that medicines are priced. And shortly thereafter, I co-founded I-MAK with Tahir Amin, who's still my co-founder today. We unpacked this problem, and there are so many ways that drugs are priced, as you just heard in the last presentation. There are so many drivers for the high cost of drugs. And maybe this is because we're lawyers, but we really honed in on patents as one of the root sources of the power to price. And so we came to this work, and we still do this work so many years later, because we think that, my colleague Rohit, who used to work for MSF, used to say, intellectual property rights, which includes patents, are the new currency. It's like money, it's like big data, it's like oil. It's become this new form, this new asset that drives capital flows and it drives power, but nobody talks about it. And I think that's the reason why many of us choose to focus here and why we founded I-MAK, is because we believe you have to go to those root sources of power if you want to dismantle them and if you want to make change. So after we started I-MAK, one of our very first cases was the Positive Women's Network in India. They had come to us to talk to us about pediatric nevirapine, which is a form of an HIV drug that they needed for their children. And they asked us to look into the patent side of this problem. Our team is basically, we jokingly call ourselves patent detectives. So we started to look under the hood to investigate the patents on this particular medicine. Now, the way patents are supposed to work, they are a right that the government gives. So if you invent something, the government gives you a piece of paper that says you got the patent, that basically gives you a 20-year monopoly, during which time nobody else can make or sell the drug. But as we started going through, not only for HIV, but for so many drugs across diseases, we started to realize that drug makers were basically gaming the system, that they were filing dozens and dozens and dozens of patents on any given medicine. And so we decided that we wanted to figure out how to stop them. And our team had come from the private sector. Our lead scientist used to be an executive in the pharmaceutical industry. And Tahir had spent years working at law firms on the other side of the fight. So they were like, we need to go in using a legal route and challenge pharma on its own terms. And so what we did was we started to hunt for what we call the blocking patent. And this is the patent where the company is so obviously just filing these frivolous follow-on patents so they can make their monopoly longer. But if you challenge it and you win, you can shave time off of the length of the monopoly. And so that's what we did in this case. And we were able to break the patent by filing, basically, it's like a litigation. And you file it and you say on scientific grounds, it's not on ethical grounds though, so it can't be about drug pricing, but on all these scientific grounds, and you make these legal arguments, you can say this patent application is not inventive, or it's not new, or it's not useful. And if you can prove those grounds, then you break the patent. So that's what we did. And then over the years, we did that on many cases, and many civil society organizations have done this work all over the world. This is actually an old slide. I would say that based on the most recent estimates, civil society has now, we've enabled closer to $50 billion in cost savings for health systems across the global south. So this is a major accomplishment where, you know, just a few people on their laptops in different countries are doing this work, and we've seen huge success. So then in 2015, we were asked to come to the US because obviously the US is in a drug pricing crisis as well, which there are many drivers for that crisis, but one driver is that the patent system is not working as intended. And so when we got to the United States, remember, it's supposed to be one invention, one patent. But on medicines, because there are different components that go into a medicine, or for many other reasons, drug companies are filing so many patents on each invention. And so we decided to do an investigation this is back in 2018, to say, well, how many patent applications are they filing on the best-selling drugs in America? And what we found, I'm going to show you what we found in 2018. There were seven. There's seven I'm showing you here, which includes one diabetes drug. But on average, what we were finding is that there were 125 patents being filed on each of the best-selling medications. And there were 71, if I recall correctly, granted on each of these drugs, which was crazy. So we put out this investigation that said, look, patents are supposed to be for real inventions, but this is the kind of gaming we're seeing in the system right now. So a drug company is supposed to get 20 years of monopoly, during which time it's the only one that can be on the market. But we're seeing that number as of 2018 is now 38 years. So the monopoly life is doubling, and we're not getting competition and prices aren't coming down. So for things like insulin, we put out a report and we partnered with T1 International on this. You know, we were able to show that this is a serious problem. This is one of the drivers that's causing companies to have a longer monopoly. And I'll show you what we found next, but basically, like, they're able to start hiking their prices as they get closer to patent expiration. So at this time, you know, when we entered the US between 2015 and 2018, we thought, well, we've litigated all over the world, so have our partners, like, let's go do this work in the US and show them, you know, how we as the Access to Medicines do this work. And this is what happened to us. The United States Patent Office is not friendly or welcoming to civil society getting involved in patent discussions. In fact, I would say, as you all embark on this next chapter of work, I would go so far as to say, The patent office and the patent system and the people who act within it in the United States do not actually believe that patents and prices should be connected. Patents are there to reward innovation. You know, if you talk to any of them, that's what they'll say. Somebody else prices it, somebody else decides how it's going to get to real people. That's not our responsibility. We disagree strongly with that statement. We think that patents absolutely have to do with pricing and patients, affordability and access, because they provide the power for manufacturers to be the only ones to sell. And so what we learned in our own experience is that we did not think and do not think that strategic litigation should happen without public pressure. And so these are the years now where we start to elevate the issue of patent abuse, where we start to put pressure on Congress, on the USPTO, on other key actors to say, we need to do something about the drug patent problem. So here I'll just dive into a couple of quick examples to illustrate the issue. And if there are questions, I'm happy to answer them, although my focus will be more on the patents, less on the pricing of these drugs. So in 2018, I mentioned we did these investigations because the price had increased so significantly between 2012 and 2018. And we knew from our partnership with folks in this movement that people were not able to afford their insulin. We found that on Lantus, the 20-year monopoly should have ended, but instead, on the first patent, but instead there were 46 additional granted patents, which pretty much doubled the monopoly life of the drug. And what was interesting about this is that the argument you would get from industry is that, well, that's invention, we have to do R&D. But FDA approval of a drug does not happen for several years after you first, early on, you file your patent. And what we were finding is the vast majority of patents on Lantus, but also on a lot of the best-selling drugs, happen after FDA approval. They happen when a bunch of people working at law firms realize this monopoly period that we have is going to expire. Other people are going to enter the market. The price is going to have to come down. We need to make as much money as possible for as long as possible. So they build these patent walls. Now, it's worth noting that the US has more applications on many of these best-selling drugs than other high-income countries. And that's not to feed the nationalist sentiment that's happening in certain circles right now in the country to say that other people are free riding. That is not what I'm saying. What I'm saying is that drug makers have found a way to actually exploit and weaken our system, and we need to focus on that, target it, and fix it. Another example is Humalog, which many of you are familiar with. The price of Humalog, as I'm sure has been discussed probably already, it increased at 10 times the rate of inflation over the last decade. And one of the things we found very interesting when we started to look into the patent portfolio of this is that when the 20-year mark ended, there were still so many patents that had been filed and granted. So now you're looking at not just what we said in the 2018 investigation, which is that the monopoly length of drugs is almost doubling. What we're finding now is that it's more than doubling because the protection on Humalog is now at 46 years. And there are still, for all of these drugs, more applications being filed. Now, I do want to acknowledge that the price of Lantus and Humalog came down this year after COVID hit. And I think that's important, but it doesn't correct for the underlying structural issues that many of these drugs that we're looking at, they shouldn't still be on monopoly to begin with. So I just want to name that. And so in my remaining time right now, I wanted to move into what does patent-related advocacy look like? We put a framework out earlier this year, and we're hoping over the next year, including in collaboration with you all and many others, that we're going to start to color or put the paint on the canvas around this. After many years of doing this work, we've identified that there are 5 basic pillars that we call RAISE that have to change if we're going to correct for the inefficiencies in the patent system, start to dismantle some of the structural inequity and start to build something new in its place. The first is raise the bar, which would address this over-patenting problem I've been talking about today, where when you raise the standard for what gets a patent and is considered an invention, you'll do a lot to shorten monopoly life and bring drug prices down. A stands for amend incentives. What we found in looking at this system is that all of the actors in the system, whether it's patent offices, patent examiners, pharmaceutical companies, every actor doesn't quite have the right incentives that we would want to see to bring the change we want. Increasing participation is very straightforward, and I'll talk about it more in the next slide. But currently, the US Patent Office and the patent offices in many countries are still a black box. It is there to serve companies and inventors to invent and to then, by extension, bolster economic growth based on current economic ideology that says you need a lot of innovation, therefore you need more and more patents. And so they do not believe actually that meaningful public participation is important. And I'm happy to send you some writing that I and others have done on this at a really high level, but we know that this is wrong. When a system affects people who take medication have to be involved in that system at every step and have to be meaningfully included, and their inputs have to shape how that system evolves. This does not happen at all. This is what I see as the Insulin for All movement's primary next chapter contribution, if this is something you all decide to take on. And standing for justice, the next one, the letter S, basically is in line with that. Currently going to court, so not just participating at the patent office level, but also to get justice, to be able to go to court or to be able to go to the patent office trial and appellate board. There's not easy ways to do that. It's very expensive. Oftentimes we don't have legal standing to go to court. And so this is an area where I think we have to demand inclusion, participation, and justice as well. And then lastly, expanding oversight. There's virtually no oversight of the patent system in the United States today. And so this is another fundamental area for intervention. So that's the what. I want to say just a couple of things about the how. I believe that communities have to lead the process for defining advocacy strategies. So I am not putting out a roadmap on this. What I want to offer are 3 frameworks for how you all could think about it. The first is, I think that there are many, many, many people across the global South, and we stand on their shoulders to do this work because there have been people doing this work now for 20, 30 years. I think we, those of us who are starting to engage in this work in the United States, we have so much to learn. I get some pleasure in thinking about this would be our way of decolonizing global health, is to call on many of those folks as our teachers and start to get trained up in what strategies have patient-led movements in other countries been doing. And I know you kicked off today's workshop with a little bit of that. On the patent issue specifically, there's so much to learn. There has been such depth and breadth of experience. So I think that would be a good starting point. The second is engaging in legal mechanisms. I think one of the first steps for this would be to start to identify movement lawyers, not just legal practitioners, but people who are going to be with you for this long ride, people who are committed to community-led processes. And I'll give you a tip here from my own years of being a movement lawyer, is that it's really important for community to hold lawyers accountable. I think that oftentimes as lawyers, and I'm speaking about myself now, I'm not pointing the finger at anybody else, we get in our heads and we get so caught up in the struggles for justice, and we have all these ideas about how we can do the work. And we shift from being servant leaders to trying to lead the process. And in that moment, I would say this is the most important part of setting the foundation as you start to think about how to engage in legal work on this issue in the US, is defining that relationship, being really clear that as community, as the movement, you're going to set the strategy. And what you need from your lawyers is to be educators, to be translators, to be true movement lawyers. And there's great work that's been done on this to like define what that looks like, that I think would be really valuable to start with. And then from there, you can think about litigation, you can think about administrative office actions, like at the United States Patent Office itself. You can think about filing amicus briefs, which might be a great place to start. But I would make sure the foundation is set right first. And then lastly, I think in the next 3 to 5 years, we're going to have to educate people about this problem. Patents are not something that's talked about in the United States. I think there's a lot of incredible work to do. I think when I think about my own organization and what I'd love to see us achieve in partnership with your movement and others in the next few years is, I think we need to make sure Congress has hearings on the patent problem. There's been some drug pricing hearings. This Wednesday and Thursday, they're going to call in the big pharma CEOs, although I don't think the insulin manufacturers, but they're calling in the pharma CEOs. They're going to probably talk about patents, is my guess, based on the subpoena they just issued to AbbVie. It's not enough. We need to have meaningful patient participation. We need to have congressional hearings. We need to have PTO holding hearings and roundtables where they give patients and communities a seat at the table. And we need the media covering these stories a lot more. And so I'm happy to come back and brainstorm with you all, but I think this is a good starting point to thinking about where the intervention points are. And then one last thing that I wanted to say before wrapping up is that this Wednesday and Thursday, we're getting a pretty rare opportunity because the Congressional House Oversight Committee in the US is going to call the pharma CEOs in. I recognize that it's probably not going to focus on diabetes medication, but to the extent that it will focus on some of the structural levers, including patents, I think there's a lot you all could do by following and amplifying and commenting on what Congress is doing right now. My colleague, Tahir, who's the last Twitter handle here, as well as I-MAK Global, are going to be following the hearings and really elevating some of the key points around drug patents, driving some of the pricing problems we're seeing today and some of the access problems we're seeing today. So if you also wanted to amplify them, that would be amazing as well. And that's it.
Which part of the process is still under patent? Because the compound glargine is off patent since a few years ago in the US. So if you happen to know what the drug companies still have patented, that may be interesting to folks.
Oh, that's really interesting. I don't know. Our legal team would know, but I'm happy to send over the information.
Cool. Thank you so much. Where do you think the best source of patent reform would stem from? Is it regulatory action? Would it be legislative action? Would it be judicial action?
Unfortunately, I think that it depends on the issue. I showed you the RAISE platform. There are opportunities to use all three of these. So for example, regulatory action could address some of the problems we've been seeing in the last couple of years around public intervention at the USPTO to challenge patents. Judicial action could rectify some of the long-standing issues we're seeing in how patents are implemented, but standing is always going to be our barrier there. There have been so many, and I think this is a really interesting story, which maybe we could spend time on down the line, but the ways in which public interest groups, from farmers to breast cancer patients, have tried to intervene in the US patent process and not been given the right basically to participate in court proceedings, does not give me a lot of optimism that we will be that successful there, unless you can meet the standing requirement that you were directly harmed, essentially commercially, and could be sued by the manufacturer. So there's some interesting creative space that you all could think about playing in there. So unfortunately or fortunately, by statute is going to be the big win. It's going to take a long time, but I think there are a lot of things that we can do along the way to get pieces of it passed in bills that are passing for other things. And so one of the things we saw in the last few years since we put out over patented and some of our policy recommendations, we saw more transparency bills get tabled on this issue, more awareness in the policymaker community that that transparency around small molecule and biologic drugs was going to be a key barrier to bringing drug prices down. And so I think bit by bit, we can start to get things introduced in bills, but ultimately raising the bar for what gets a patent is going to be probably one of our biggest fights. And that's where I think it's going to have to be done by statute.
Yeah, there are a lot of opportunities to pass legislation that would challenge the patent problem head on, and Congress hasn't gotten there yet, but I think there are probably some hopeful signs in that direction.
Let me just say one more thing about this. I think, in the access to medicines movement over time, we work in two ways. There's the really, really technical work, and then there's public pressure. And our biggest wins have come at the moment when public pressure is really built up. What I've noticed over, especially maybe the last 10, 12 years, is that as more and more people get into this work, they get sucked into the technical vortex. And I don't think that's how we've gotten our biggest wins, like South Africa in '99 for HIV drugs, or getting the Indian patent law amended in 2005 to allow for more generic competition. I think our biggest wins have happened when communities and the global community at large have mobilized and made this an issue and brought that public pressure and heat. And so that would be my wish and my dream, is that we can really generate that kind of power going forward.
Absolutely, and that's what we're all here to learn how to do together, fortunately. So thank you. That's a really good grounding statement for all of us. So there could be a comparison between patent abuse and medical malpractice, and that both of them are, potentially very damaging to patients and can harm people's health. She's wondering if that might be a kind of argument that you could hear at a congressional hearing in the future.
Yeah, I think that sounds powerful to me. I think that you should use that. I like it. I have been talking to a lot of people in the patent legal community behind the scenes who probably won't speak on this publicly, but they have urged me, as we do more talks for patent lawyers, and a lot of people who work in the patent system are just trying to get patents filed. They're not thinking about the policy issues. So as we try to bring this to them to say, hey, you're part of this big problem, they've really encouraged us to appeal to this ethical duty that lawyers have. And I think that's why your line here is just so powerful, because I think it appeals and makes that land in a different way.
Absolutely. So if you know of any efforts, or if there may be any efforts in the works to take a test case to court in the way that other social movements have taken test cases to court.
Yeah, unfortunately, the history of this in the US does not give those of us maybe who are a little more jaded, it doesn't give us a lot of optimism, just because this has been tried, like I was saying, by the farmers, by the breast cancer patients, in other cases. So there's a level of defeat, I think, that some of us feel over time. But people in other countries have done this and won. Like the Lawyers Collective, who I used to work for, they brought a test case on this for TB patients, and they won in India. I think the US has standing itself is viewed differently here, like this idea that you have to be harmed. And what harm, I mean, it's just shocking, right? Like, why wouldn't a patient who couldn't afford a drug be harmed? But I think we can dig into this, and I think you all should form your own conclusions about how the law has worked out, and go seek alternate legal opinions and see if you can, again, build the public pressure to make the conditions right, that somebody would be willing to look at this differently. I think without the public momentum around a case, I don't think it will be successful.
Understood. But there's, always opportunities to continue pushing, as you said. So wondering how the recent state price cap legislation, which is sponsored and supported by other diabetes organizations such as the American Diabetes Association, may factor into the broader patent issue that you've been talking about.
Yeah, it's an interesting question. I think that there are going to be challenges to price caps on this ground because it conflicts with the idea of monopoly powers through patents. I believe, if I'm not mistaken, the folks at Portal, Amit Sarpatwari and Aaron Kesselheim, I think that they've looked closely on this, and they actually have a presentation where they walk through how state and federal law in the US work out. So we can put that on the list of resources that I send you all.
How if standing only works with regard to having a commercial interest in an issue, such as wanting to take insulin, versus having a health interest in an issue. So for people with type 1 diabetes, that would be the harm caused by drug companies suing to prevent generic manufacturers from creating biosimilar insulins, for example. And she's wondering if that's been tested.
Yeah, that's what I'm referring to when I talk about the farmers and the breast cancer patients, although not specifically what you're raising here, but the same general principle is applicable. And I believe in the case of the farmers and Monsanto, the way the law is basically construed is you have to be at risk of being sued by the patent holder. So in that case, it was about farmers where if the seeds sprinkled over from the neighboring farm, this was a GMO case, and that farmer, were they infringing on Monsanto's patents? And so here the farmers were even able to say, yes, Monsanto's probably going to sue us. And then Monsanto, I think, put out a letter saying, oh, we're not going to sue them. And then the judge said, because they are not at imminent risk of being sued, they don't have standing. So there's just the way the courts interpret this is just so incredibly narrow. I think it is worth making this an issue, but I'm not sure how we're going to win it. And it's probably going to take some people with constitutional legal expertise in the US. And there are folks both at the ACLU, what was formerly the Public Patent Foundation, Dan Ravitcher, who I'm sure could sit down with you all and really walk you through the history of how this played out.
Absolutely. And there hasn't been a social movement in history that hasn't required some creativity and some outside the box thinking. So big, well-moneyed interests that are getting that money and power at their expense.